Wow, this is a remarkably orderly bunch. I am duly impressed. I'm Ron Sullivan. I teach here, and as moderator, my principal duty will be to stay out of the way. So let me introduce our two panelists. First, we have to my immediate left and your right, Julia Jenkins. She is a Los Angeles, California native. She graduated from Cardozo School of Law in New York in 2016. She joined the Legal Aid Society of New York's criminal defense practice in 2018, where she represents indigent clients facing misdemeanor and felony charges. She also serves as a representative of the Black Attorneys of Legal Aid Caucus, which promotes racial justice for both attorneys and clients. Next to her, we have Elie Mystal. He is the nation's justice correspondent, covering the courts, the criminal justice system, and politics, and the force behind the magazine's monthly column, Objection. He is also the Alfred Nobler Fellow at the Type Media Center. His first book, Allow Me to Retort, A Black Guy's Guide to the Constitution, which was just a fabulous and hilarious read, was published on March 1st. Mystal is a graduate of Harvard College and the Harvard Law School, former associate at Debevoise Plimpton, and a lifelong New York Mets fan, which is quite bold to include in a bio in Boston. Prior to joining The Nation, Mystal was the executive editor of Above the Law. He's a frequent guest of MSNBC and Sirius XM. So we're going to begin with opening remarks, and we will start with Julia Jenkins.
Thank you. Thank you for having me. Good afternoon, everyone. As we all know, I'm a public defender. And as public defenders, our job is to defend indigent people and to protect their constitutional rights as best we can. In New York City, where I practice, the overwhelming majority of our clients are Black and brown. Our clients come from historically disenfranchised communities, divested of adequate housing, educational resources, and opportunities for employment and economic advancement. This dearth of resources has led to high rates of crime, poverty, and violence. The typical governmental response to these conditions has been to both criminalize and violate the constitutional rights of Black and brown people under the guise of ensuring public safety. Violating the constitutional rights of Black and brown people is and always has been part and parcel to what society considers necessary governance and effective crime control. Black people's ability to exercise our constitutional rights should not be predicated on having low crime rates in our neighborhoods. This is why, as public defenders, our role is not only to defend our clients and protect their constitutional rights during the pendency of the case that we're representing them in. Our role is to promote the recognition of constitutional rights that have been historically denied to communities of color, so that ultimately we can all live as free and equal citizens in this country. That's why I, along with my BALA co-representatives, chose to join with other like-minded public defenders in filing an amicus brief urging the Supreme Court to address New York's denial of the Second Amendment right to bear arms. Concerning the Second Amendment, our position is simple. If there is a constitutional right to bear arms, it should apply to all Americans. There has been some talk about abolishing the Second Amendment entirely, as well as a longstanding debate about whether the Second Amendment actually grants an individual right to bear arms in self-defense. As worthy as these conversations may be, the reality is that in 2008, the Supreme Court expressly held that the Second Amendment bestows an individual right to possess firearms in self-defense. Like it or not, that is the current state of the law. And so that, again, is why our position is that if there is a constitutional right to bear arms, it should apply to all Americans. Unfortunately, Black and brown people have been continually denied their right to keep and bear arms up until this present day. Throughout history, a variety of mechanisms have been used to deter Black gun ownership. Criminalization is the most popular tool. Criminalizing the possession of firearms is one of the most common ways for Black and brown people to become involved in the criminal justice system. In New York City, many Black and brown people are arrested and vigorously prosecuted for mere possession. not just in cases where they possess the firearm in public, and not just in cases where they possess the firearm with an intent to use it unlawfully, for mere possession of the firearm alone. The consequences of such an arrest begin immediately. In most cases, the district attorney will request and the judge will set a high bail. If the client is indigent, it's unlikely that they will be able to make that bail. So they will be fighting their case from inside New York City's most visible badge of slavery, Rikers Island, where 16 inmates have died in the last year alone, and 2 died in the last 2 weeks. Aside from the obvious physical and emotional harm that pretrial incarceration causes, pretrial incarceration also causes a loss of employment, housing, and strains family and community connections, and this is all before the trial. In New York City, mere possession of a firearm is most often a Class C violent felony, which carries a 3.5-year mandatory minimum prison sentence. In the best case scenario, meaning a client has no criminal record, it's their first arrest, they had employment, family, community ties, they will be offered 2 years of prison time and 2 years of post-release supervision. In the majority of gun convictions, clients will receive prison time, which will disrupt their lives and the lives of family members, relatives, and other people who they have human connections with. Then, of course, gun convictions usually come with felony records. It goes without saying that a criminal conviction comes with a host of collateral consequences, including discrimination in housing, education, employment, as well as the loss of property, family, and oftentimes children. Convicted felons will be denied the right to vote and meaningfully participate in society to some degree in every state in America, including New York. And all of this because our clients choose to exercise their Second Amendment rights, something that, if done in many states, would result in no criminal charges, or at most misdemeanor charges. Meanwhile, crime rates remain high in many Black and brown communities, despite claims that strict gun laws reduce crime. And illegal guns continue to flood the streets. Law enforcement officers are fixtures in our neighborhoods, literally posted on every corner. Yet they fail to protect us from the crime and violence that persists. In fact, they oftentimes add to the violence and lack of security and safety. And it's for this reason that, as reported in the New York Daily News last week, many Black and brown youth would rather arm themselves for self-defense and risk the heavy penalties that come with it than to cooperate with the police. I think that we all can agree that the state has a responsibility to protect citizens from violent threats. That said, assuming that policing is perfect, which it is not, police officers cannot be everywhere. When the state is unable or unwilling to protect citizens against imminent threats to their safety, the Second Amendment grants law-abiding citizens the right to protect themselves and their families using a firearm. We believe denying that right to some while granting it to others is unconstitutional. One of the biggest stated concerns about protecting gun rights of Black people is that promoting individual rights for self-defense leads to more guns, which allegedly leads to more violent crime. This is an argument that many gun control advocates make, and they often cite various studies that purport to prove this. But the reality is that claim is at best questionable. Over the last few decades, since the 1980s, the number of guns in this country has increased astronomically. Today, there are more guns than there are Americans. So by this logic, the more guns equals more crime logic, then violent crime should have increased since the 1980s. However, the fact is that violent crime has decreased during the last few decades. The claim that more guns equals more crimes, therefore, is at best suspect. Is gun violence a problem in this country? That argument can certainly be made. But the dominant approach to addressing it, however, has largely been to criminalize mere possession. Criminalizing the possession of a weapon does not disincentivize violence or crime. If an individual is intent on committing any act of violence, they will commit that act whether using a gun, a knife, or any other weapon they can get their hands on. Criminalizing mere possession of a firearm creates criminals out of otherwise law-abiding citizens with legitimate self-defense concerns. It justifies proactive policing policies, incentivizing police officers to aggressively stop and frisk people who are not suspected of having committed any crime. It provides a pretext for more surveillance and militarized policing of our communities. It does not curtail violence. The way to address crime and violence in America is by addressing its root causes, which I alluded to earlier. We need to address the historical disenfranchisement and divestment that created the conditions that lead to crime and violence in Black and brown communities. If you go anywhere in the world where there are high rates of crime and violence, you will find the same conditions there that you find in the poor communities, particularly poor communities of color in America. Lack of economic resources and opportunity, lack of adequate education, housing, healthcare, and over-policing. If we actually want to reduce crime and violence, that is where we need to start. Our communities need resources that teach the skills necessary for success in our society. We need restorative and transformative justice programs that address the harms caused by violence and allow for victims to heal and perpetrators to be held accountable and to receive the interventions they need to address the underlying traumas and mental health issues like anxiety and depression and the poor conflict resolution skills that lead to gun violence. What we don't need is more laws that criminalize behavior protected by our Constitution and are unequally enforced against communities of color. We don't need enhanced stop and frisk policies that target young Black and brown men for harassment, arrest, and incarceration. We don't need specialized units of rogue cops who violate the constitutional rights of young men with impunity in the name of protecting our streets. And we don't need to compromise our individual rights in the name of achieving public safety. Thank you.
Thank you. So I want to try to pull together, hi, by the way, I'm Ellie. I want to try to pull together some of the themes that we've been talking about, I think, all day. And to do that, I want to start with the Anti-Federalists. Because my contention is that the Second Amendment is working as intended. Because the intention of the Second Amendment was to kill Black people. That's why it's here. And for evidence of that, I go straight to the Anti-Federalists. So here's a quote from, it's actually a quote from the New York Times from Professor Carl Bogus, but he's referring to the debate that was happening from the Anti-Federalists against the Constitution before the Bill of Rights, when Madison was just like, no, it's fine, and George Mason was like, no, we need amendments. Like, what was George Mason? What was Patrick Henry? What were they asking for? Well, here's the debate. Here's a debate that a speech that Mason was giving. Mason at this point is the governor of Virginia under the Articles of the Confederacy. Here's a speech that he was giving according to Professor Bogus. During the debate in Richmond, Mason and Henry suggested that the new Constitution gave Congress the power to subvert the slave system by disarming the militias. Slavery is detested, Henry reminded the audience. The majority of Congress is to the north, and the slaves are to the south. The argument was that federal militia, if the federal government could raise the militia, they could not raise the militia. And the militia was the primary way to put down slave revolts. Now, I'm from Haiti, right? So my family is from Haiti, so I know a bit or two a thing about slave revolts, right? Sometimes they work. And the way that they work is when the slaves massively outnumber the white masters, and when the slaves are equally armed as the white masters, as what happened in various parts of Haiti during French and Napoleonic rule. In America, whites always outnumber the slave population, the enslaved population in the South generally. But in pockets, places in Virginia, places in South Carolina, at the founding, enslaved people outnumbered the whites. When there would be a flare-up, a slave revolt, they would bring up their militia to crush them. Well, if the federal government could control the militia, well then the federal government could say, well, we're not raising the militia to crush your slave revolt, and then Virginia would be SOL. Back to Henry, if they neglect or refuse to discipline and arm our militias, they will be useless, and the states can do neither, this power exclusively being given to Congress. So that was their argument. Fast forward to DC versus Heller. All right, Scalia is, for the first time in American history, inventing a right to bear arms for personal self-defense. First time that's being written down ever. All right, so now here's how he describes the Anti-Federalist argument, going back to this Mason-Henry debate that I just quoted. This is actually from Scalia's opinion in DC v. Heller. I am reading it from my book to remind people that I've written a book. But you could read that online yourself on case text or whatever. The Anti-Federalists feared that the federal government would disarm the people in order to disable this citizens' militia, enabling a politicized standing army or select militia to rule. The response was to deny Congress the power to abridge the ancient rights of individuals to keep and bear arms, so that the ideal of a citizens' militia would be preserved. That's BS. He made that up. You can see in his writing that he's talking about the same debate, and he just leaves out the part where the reason why they wanted this idealized citizens' militia was to kill enslaved people. That's why he wanted it. So Scalia, in that moment, while he is inventing a new constitutional right, he is also whitewashing the history of our country and the history of this amendment in particular. Now, just as an aside, if somebody wants to say to me, well, actually, Ellie, the Second Amendment has evolved from its slaver intentions, and now it has evolved to the point where it protects the right to bear arms, I would be interested in that argument. I'm a liberal. I think the Constitution does evolve. But conservatives can't make that argument to me, because if they do, they have to kind of abandon their whole intellectually bankrupt project. So there's that. So anyway, the point is that what the Second Amendment is doing is to control black and brown people in this country, and that's what it was intended to do, and that's what it's still doing today. We can now go into our current discussion about self-defense laws, which have come up a couple of times today. Self-defense laws, folks, are the most provably racist laws that we have statistics for. If you are a white person who kills a black person, you are 250%, according to the National Urban Institute, you are 250% more likely to be let off on a claim of self-defense than if you're a white person who kills a white person. 250%. In a stand your ground state, that goes up to 350%. If you're a white person killing a black person, you've got a better chance getting off than you do of hitting the lottery. All right? That's how this country rolls. Self-defense is inherently an argument that is made by white people to justify why they just killed a black person. That's the Second Amendment in practice. Now let's go to Bruen, which we've talked about a lot today, right? Now, if you listen to oral arguments, which you can do because now we have live audio of the Supreme Court, we should probably have cameras in the Supreme Court. I'm going to make an aside of my most disappointing moment was when, in the hearings this week, was when Ketanji Brown Jackson was asked, do you favor cameras in the courtroom? And she was like, meh, like just say it, we need it, but whatever. If you listen to oral arguments in the Bruen hearing, you probably heard Samuel Alito say, well, we need to be able to have our gun rights because if the criminals are packing, like on the subway, we should be able to defend ourselves. Now, for the younger people here, you're not going to know what that reference was to, but for the older people, that was a reference to Mr. Bernard Goetz. In 1984, Bernard Goetz, who had been the victim of a mugging, decided that he needed to arm himself to protect himself from crime. So he is now walking around New York City packing. In violation of various laws, doesn't matter. He gets on the subway, in violation of subway law, just armed. He claims that 4 black youths attempted to rob him. Taking their arguments, his argument as far as I can, it appears that one of the black people may have said, give me $5 in this very menacing way to the nice white man on the subway, who then shot all 4 of them. One didn't end up killing any of them. One of them permanently mentally damaged from the bullet in his head that gets left there. Shot all 4 of them. He was tried, got off on a hung jury, tried again, and acquitted, except for the gun charge. Bernard Goetz was not convicted for attempted murder, was not convicted for assault, was not convicted for being a dick. He was convicted for the gun charge. It was a violation at that time to bring a gun onto the New York City subway. And that is what Alito is referencing in his oral arguments during Bruin. He is referencing the Bernard Goetz situation. He is referencing the idea that we need to be allowed to go on the subway with our guns because you never know when a black youth is going to ask you for money. And that is then his basis for overturning, settled precedent in New York for 80 years, I think, right now is where that licensing requirement comes from. That's his argument. Again, self-defense provably racist, and what they want self-defense to do, what they want the Second Amendment to do, is to continue the killing of black folk. Now, what do we do about that? And this is where we get to the brief. So I think that the public defenders completely correctly identified the problem. The gun laws are racist. They are applied in a racist way. The idea that to get a gun license in New York, you have to go to NYPD? Are you kidding me? How is that even allowed? The last people I should have to go, if we're gonna say that gun ownership should be equally, should fall under the Equal Protection Clause and that people should have equal access to firearms, how is it even possibly fair that I have to go to the NYPD to ask for a gun permit? That doesn't even make sense unless you understand what the Second Amendment is really designed to do. So how do we fix it? So the brief says we fix it by basically liberalizing gun laws. And where I depart from that is the idea is, and I don't think I'm breaking new ground. If I go onto the subway with my new liberalized gun rights and shoot 5 white teenage boys who were bothering me, who thinks I'm walking away? Who thinks that I'm getting out of jail? Who thinks that I'm taking a walk on that? Right? Nobody does. But if a white man shoots me and my son and my other son because he was afraid that my big lips were going to suck his soul out of his body from across the aisle, if he shoots me for that, statistically, he's got a great chance of taking a walk. So I don't think that we can solve the problem by liberalizing gun laws, but where I disagree with some of the other panels that we've had today is that I also don't think that we can solve the problem by further restricting gun laws. I think laws are of no more use here. What we have to do is change the people who are interpreting the laws. Now, I happen to believe that we've been living in a justocracy at least since the Supreme Court picked the president in 2000. I think it's probably, you could argue that we've been living in one since 1954. But I'm going to say, at the very least, since 2000, the Supreme Court in Bush v. Gore picking the president, and everybody else just being like, okay, that the 9 people on the Supreme Court are the most important factors in what laws we have or don't have, in what rights we have or don't have. It doesn't have anything really to do with the legislature. It doesn't really have anything to do with the president. It has to do with the 9 people on that body. We are living in a justocracy. And so where I go is that it doesn't really matter what law I write. It doesn't matter what the law says. It doesn't matter how I shade it or how equanimally I put it. Because if I don't have 5 Supreme Court justices who agree with me, then I don't have anything. The conservatives on the Supreme Court have shown time and again over the past 20 years that laws do not matter to them, that precedent does not matter to them, that they are outcome determinative and they will go find the outcome they want and backfill what the law needs to say to get there, and they'll argue that they can do it because that's what Earl Warren did. They don't care. So if you're not changing who gets to interpret the laws, you're not changing anything. You're playing at the margins. Now, obviously, that leads me to a court packing thing, which is, not just a panel for discussion for another time. But when I say we have to change who's interpreting the laws, I also mean that we have to change kind of our entire culture around gun rights, our entire language around gun laws, and thus our entire language around violence. So the closing story I have is about 10 years ago, kind of after Trayvon. I'm still on Above the Law. Most people don't know who the hell I am. I'm on Geraldo, because I was on Geraldo. And he asks me, This is again. This is in the aftermath of Trayvon. This is in the aftermath of George Zimmerman, getting off for killing Trayvon Martin. And I'm doing my thing, talking about like how we need, better gun restrictions and whatever. This is again, I believed that at the time, that more gun restrictions would actually help. This is kind of before Kavanaugh. Anyway, so he asked me, well, what are you saying? You're saying that you don't have a gun in your home? You're a public person and you don't have a gun in your home? And I'm like, no. I live in a New York City apartment. Why would I have a gun in my home? It's gonna shoot my neighbor. Well, Geraldo, what if your home invaded? What if somebody comes into your house? I was like, I'd run if it was safe. What about your wife? She's faster than me, bro. He could not understand how a loud, aggressive, bombastic black man, understanding just how racist this country is, understanding just how racist the cops are, could not understand how I could, A, not be armed myself just for personal self-defense, but then particularly, B, how I could, leave potentially my wife and children to the vagaries of crime. And then certainly couldn't understand how I could, in his face, without artifice, say, well, the right answer always is run if possible. Flee if you can, because it's safer that way. That couldn't get that. And that was right after. So now, kind of more famous, people know me more. I get a text every time I pop on Tucker. I get tons of threats, not always death threats, just just threats, not always death. I don't want to oversell my point. And sometimes they're off-putting. I talk to my friends. I talk to my black friends in media sometimes. Like, man, how do you guys deal with this? And they're all like, well, you should probably get yourself a gun. You should probably arm yourself because that's what these crazy white people are doing. You need to arm yourself against them. I tell my black friends, well, no, because it's statistically still more like, I have 2 kids now. I have a 9-year-old and a 6-year-old. You think I'm putting a gun in my house? That's so much more dangerous for them than anything these white supremacists can throw at me. That's so much more dangerous for them and their little friends who come over to play, statistically speaking, than anything that any you shall not replace us tiki torch person is going to do to me. The gun in the home is what leads to injury and death. The gun in the home is what leads to domestic violence and sadness. That is the problem. And until we are able to kind of culturally, as a polity, kind of understand and address that, understand and address the fact that the thing that you think keeps you safe, the equalizer argument, doesn't actually work, isn't actually statistically significant. You are in fact more likely to harm yourself or a loved one than you are a criminal or a home invader. Until we get that change going, we're gonna be swirling down the drain. It's gonna be the same arguments against the same people in a kind of endless death grip. So that's my answer both to the public defender brief, but also to Alito, and also to people who are like, oh, we gotta ban bump stocks, and also to the alcohol, tobacco, and firearms. None of this changes as long as our culture is as broken as it is, and none of this changes unless you get 5 Supreme Court justices to agree with you, or in my court packing idea, 15 Supreme Court justices to agree with you. That's what I got.
Great, thank you. So the organizers want this to be an iterative process, and I'm happy to start the questioning off if no one has any immediately, but feel free to jump in. So I will start with you, Julia. So let's assume that I agree with all your data, everything you said, and I do. I started my career as a public defender. I don't know if you knew that. So absolutely, yes. Historical divestment, over-policed, over-prosecuted, over-incarcerated, et cetera, all correct. I walked in at the very end of Professor Siegel's comment, so forgive me if you guys have resolved this whole thing over the course of the day, but I suspect that she said something to the effect that there are, earlier before I walked in, that there are two issues with the brief. One is that the disequalities that you describe speak more to equal protection than they do to the Second Amendment, and are more easily resolved by an equal protection argument than a Second Amendment argument. And two, that even if a court were to resolve the argument on a Second Amendment ground, it would, the arguments would elide all of the race stuff and find some other basis to rule on. So I'm wondering, what do you say to her?
Well, I mean, I think she's absolutely right about the equal protection argument, right? This is an issue of equal protection, but it's also an issue of an individual right. And like I said, you know, if there is a constitutional right to bear arms, then it should apply to everyone. And we felt like the equal protection argument would not be successful. And so we went with the Second Amendment argument. It just made more sense.
Can I just say one thing that goes to the Bernard Getz story, So, for reasons that escape me, when Heller came down, Harvard asked me to do a comment on the Heller case, and at that point, I hadn't really written on the Second Amendment, so I did a deep dive reading about gun stuff. Mm-hmm. And I was just amazed at how, so it's kind of a story about how Heller is based on living constitutionalism, like the whole of the narrative that Scalia is writing is about 20th century gun rights logic. So it's living constitutionalism talking the language of originalism, which is something I've argued for a really long time, but I just did a reading of that. And the axis of it is hyper-racialized. And the language, the imaginary of the new right in the late 20th century is not on a white-black expressly, but on a citizen-criminal story. And so much of the talk of the gun rights movement is about citizens versus criminals. And the reason I'm saying this is that so much of the self-defense talk is about having a gun, and it's in Heller, to defend you and yours against this criminal invader. And so I worry that the court that would interpret the Second Amendment to deregulate, to use the language that we had in our paper, would deregulate it in a way that would still leave licensing there. And so you'd still have to show that you had a certain kind of record to be eligible for a gun. And so there would still be a kind of virtue story about who gets guns that would essentially carry the same narrative, I guess, that Ely is talking about, you know? So it wouldn't be expressly by race, it would just be who's entitled to have a gun and who's not entitled to have a gun. So it'd still be, practically speaking, I'm assuming, a licensing system, even if the court took apart New York's one, there'd be some licensing system. Someone can correct me if I'm not right about this. I'm just surmising one would. So there's still a licensing system left. So
Yeah, Amy Coney Barrett would say, guns for everybody except for felons who are just immoral and don't, and then we'd be right back to.
And what I want to say, therefore, is that the criminal law could then still have a felony for possession without a license. Mm-hmm. And so I guess what I'm saying is so much of the world that you're describing could still persist, even with the Second Amendment enforced by a very libertarian court. So it would take a court that was committed or concerned about the concerns you're concerned about to use the Second Amendment engine to get to the concerns that are moving you, which is a little bit the conversation I was having earlier with Adam, that unless your Second Amendment is informed by your racial justice concerns, you'll deregulate in a way that will be indifferent to the underlying problem. It will produce a world not only indifferent, it will probably produce a world that could reproduce that you're concerned with. That's what I guess I'm trying to say to you. And that Aziz Hook's paper earlier today was describing how you could take apart a world in Chicago and keep reproducing a world of racial inequalities.
Right.
The criminal justice system would just keep almost like reproducing it unless you're actually committed to dismantle a system of race in the criminal justice system. You could keep that's what I'm concerned about, because there'd be this idea that criminals shouldn't have guns, and that idea would be the engine in the system, or so I'm worried. That's the thought that I have.
I mean, I don't necessarily have a problem with the proposition that criminals shouldn't have guns.
Right. So then it's who's enforcing that system?
I mean, so the thing is, if this is an individual right, then all law-abiding citizens should have the right to bear arms, right? And so that's the position that we're taking. The issue with policing and inequality, they're really two separate issues. And while they are related, they're two separate issues. And your constitutional right to bear arms in self-defense or any other constitutional right should not be predicated on, whether the state is going to treat you fairly, or, whether private citizens are going to abuse, you because you are exercising that right. And so, yes, I think that your concerns about racial justice are important, but they need to be addressed in a way that does not deprive people of their constitutional rights.
So can I come at this from the other way? Because this goes to my pox on all houses kind of thing, right? Because while I'm not particularly in favor of liberalizing gun laws for many of the reasons that you bring up, I'm also not really in favor of overly restricting gun laws because almost of the same problem. So I want to, again, for the younger people, I want to take you back to the 1960s, where we have the most restrictive gun law in America up until that point, the Mumford Act, right? The Mumford Act, restricted open carry, restricted long guns in California. It was signed by, and this is a blast from the past, it was signed by Republican patron saint Ronald Reagan. In California, he signed the most restrictive gun law in the country. Why? Because black people in Oakland, California got some guns. They got guns to defend themselves. They got guns to cop watch, it was called. They were, as cops were policing their communities, the Black Panthers were there armed, watching the cops, not doing anything, watching the cops with their long guns. And white people in California freaked out. Could not handle it. Ended up passing this Mumford Act, the most restrictive gun law in the country. The Mumford Act was constitutional, according to the Supreme Court at that time, under the Second Amendment. This is a law far more restrictive than the law that Scalia strikes down in D.C. versus Heller. But because everybody understood who the problem was the black people, there was no problem with the Mumford Act in terms of constitutionality. The Mumford Act wasn't actually overturned until now Reagan is president. Now the NRA has there's a whole backstory with the NRA where it used to literally just be we just want to kill Bambi's mom, and then it kind of metastasized into what it is now, because hardliners who were against the Mumford Act took over the NRA in the late 70s, right? So now the NRA is what we think of it today. Reagan's president. They pass this federal law basically massively deregulating gun sales and gun purchases all across the country in response to the Mumford Act, because by that point they were no longer worried about Black Panthers in Oakland, and we could get back to what gun rights are really about. So I kind of come at it from both ways. Liberalizing laws doesn't really work because cops are going to be racist. Restricting laws doesn't really work because cops are going to be racist. What you have to fix is the racist cops. What you have to fix is the racist judges. Because if you don't, then these problems will just keep happening again and again and again and again.
I guess the only thing I'll add, and I'll get rid of this mic, is that I think law is necessary, and changing the law enforcer's frame of mind has to be part of the answer. But it's also really fascinating to see what is being invented by way of these violence interrupter groups and the efforts to use resources to prevent the kinds of conflict before they happen, and those kind of interventions, rather than just using the criminal law after the fact. And that stuff seems And that's not just new culture, that's new institutions that are being created. And these themes seem really critical and really promising, so.
Right, we've got two hands, one in the back and one in the front. Yes, I'm sorry. You look behind you.
Hello. Good afternoon, this afternoon. I guess I have more of a comment than question. I am a colleague of Julia Jenkins. I am also a BALA co-rep, so we all were involved in signing on to the brief. And I think my comment first is more so an issue that Adam, that's your name, right? Okay, alluded to, which is, I'm hearing what everyone's saying, and I think what bothers me is this idea that because it can't be rolled out in a perfect way, then we should just accept it. And maybe that's not what's being said, but that's what it feels like to me. So, Riva, I believe is your name, it's like, well, let's not leave it to the courts because they traditionally have sucked at this. Let's leave it to democracy. Well, they've sucked at it too. Because if they had the opportunity, which they have, legislators have not fixed this issue. I mean, I'm also a public defender in Brooklyn, and to Julia's point about, who's gonna have these guns, my two most memorable clients were not criminals, and they only had guns. One was in a safe box in his house, tucked in some room in a closet where no children lived. Man is 65 years old, never had a prior, and is now looking at jail time. Another one was a young guy saying, had a child but didn't live with them, was traveling in an automobile. Didn't matter. They were law-abiding citizens, but for the fact that they chose to have a gun, both in innocuous situations, and now we're facing years and convictions. So it's like, I understand that the Second Amendment, should the Supreme Court decide in Bruin's favor and say, fine, let's everybody have the opportunity to have a gun. I understand that there's gonna be issues with licensing. Are they gonna make them super expensive so that half of our clients wouldn't even afford them anyway? Probably. Are they going to now create all these demarcations where, you can't have them within 100 feet of a New York City public housing? Probably. So we're gonna have the same problems, but I still think it's better to do something than do nothing, expecting that we have to wait for the perfect solution and, to do something or to frame it better. And so my question then to Ellie, right, is if neither one is the solution, and I think this is like the catch-all, question, what would you say is then the solution? Because respectfully, this whole changing the minds of racist cops, that's also equally to me pie in the sky. I don't see that happening, and so what do we then need to do, or what do you think is a more realistic approach to then addressing this issue?
Yeah, so I think that, and I kind of alluded to this, I think that you really have to start with laws about how the gun is being used, right? Like, so I don't think that you're going to be very effective at again, if you're not going to be effective at liberalizing gun laws, and you're not going to be effective at restricting gun laws, then what you could perhaps be effective at is changing the standards of self-defense, so that you are getting rid of stand your ground kind of laws, because we have a statistical evidence that that's going to get more black people killed than not having stand your ground laws, right? So that you can change the laws around castle doctrine. You can change some of these ideas that take the gun that is already inherently dangerous, but then basically give white people license to use the gun in various situations, right? So that's one end of the spectrum. I think on the other end of the spectrum, you also need to really look at much more harshly penalizing violence against women acts, right? Like, so we need the Violence Against Women Acts. We need domestic violence to be taken much more seriously. We need to have basically a much quicker hook when it comes to restraining orders and other things to protect partners. And then certainly we need to, as you put it, you don't have a problem with criminals not having guns. Okay, well then we should really focus on making sure that men who have a restraining order taken out against them, have some kind of from my perspective, any little thing that you can get a man on to make sure that they can't have a gun to menace their partner with. We gotta go kind of all hands on deck and get those laws passed, right? So if I'm saying that you can't really effectively deal with people's ownership of guns in a race-neutral way, which is fundamentally what I'm saying. Then I think you have to really focus on getting race-neutral use of guns laws changed, passed, reconstituted, and reorganized. Is it super, and to close the point, I mean, and this is, I've written about the public defender a brief, like, you're not wrong. Like this, the fundamental thing, like that gun laws as experienced in our country are racist. You're not wrong. The stats are not wrong. As you were saying, Ron, like the fundamental data here is not wrong. It's a huge freaking problem. What's the difficulty is figuring out how do you unpack that problem. So I totally agree. You don't want to let the perfect be the enemy of the good. I just don't think that it's going to be effective to liberalize these laws because racist cops and racist judges and racist, people will, as you were saying, kind of rebirth and recreate the problems.
We had a question here. Yes.
Yeah, I kind of had a question and a comment. So full disclosure, I co-wrote the Amnesty International brief, and we took the opposite perspective that there ought to be, that racial discrimination would not be alleviated by striking down New York's law, so we actually supported it. But the reason that we did so wasn't a dispute over whether there is racism in America or whether individuals are more subject to violence because of their color, but because of the statistic, which is a little different, Julia, than the one used. It's not that more guns leads to more crime, it's that more guns lead to more deaths. And that's true, right? That statistic is true, that when you have more guns available, everybody has shown that in fact, when you're awash in guns, because as Ellie said, 60% of it is actually suicides. Suicides are 85% likely to be effective with a firearm because you have no ability to intervene. So 61% of the 40,000 that I said is actually suicide. The other 40,000 is things like the mass shootings, domestic violence, and attacks on people of color. So from our perspective, I just offer this as, not in criticism, but just to say, from our perspective, a licensing regime of some kind that involves background checks, that actually restricts access to firearms for everybody is a positive, because the more guns you have, the more death and violence you have. And to the point that Ellie made, if you have a gun in your house, you're much more likely to be shot accidentally by somebody coming into your house than use it against a would-be attacker. So some of those statistics, which are in our brief, I think really suggest that you need some kind of legislative scheme in order to handle the extraordinary levels of violence afflicting all of society. On the racism point, with respect to Bruen, the question I have for you is when I read the pleadings in the case, and I read the case, it seemed to me that the Supreme Court took cert, and maybe somebody else has an answer to this, that when cert was granted, it really was with respect to the individuals who had applied, who had been denied. And one actually, I think, was some of his rights were allowed and not the others. And so my question is, it seems odd to me that this case that was originally around these individuals has become this huge case to discuss these other issues that actually really, I mean, talk about a case in controversy requirement. This was not a controversy in the case. And maybe somebody can answer that, about why this very, very narrow petition of the court kind of mushroomed into let's drive a truck through the Second Amendment, which is how I see it, and just basically open it up. But
Yep.
it's really
Kavanaugh is how that happened. But
yeah, I mean, so I don't disagree with what you said at all. Actually, I'm just trying to give that we had a different perspective, which is that the Second Amendment should actually be restricted because there is so much violence, and that this case has become such an extraordinary vehicle for, the Second Amendment is just kind of, I just have a question about it. Maybe somebody can answer that. Ellie can talk about Kavanaugh, so thank you.
Well, I think I'll just say that the issue in the case is whether New York's law is unconstitutional. And I don't think that, from what I've heard, everyone sort of agrees that the law, as it's currently written, is, the Supreme Court will likely rule that it's unconstitutional. And so that's the issue. Now, if New York wants to enact some sort of licensing scheme that does not infringe on people's constitutional rights to bear arms, and that is fair and that applies to everyone, then I don't have a problem with that. So, I mean, I don't see an issue with the position that we took in relation to the original petitioners.
And if I can just get Julia's back here for a second, like, I feel like we can all agree, right, that like NYPD should not be issuing gun licenses, right? Like whoever is going to do it, however it's going to happen, it shouldn't be the cops, right? They've lost the moral authority to do that. And what the actual issue in what the cabled issue in Bruin was supposed to be was this question of having to show special need, extraordinary need, to own a firearm, right? So like to need a firearm, right? So that's how it kind of got expanded, because the core issue, should I, as an African-American citizen, have to show a particular need to have a gun that can be defined by NYPD? I think that pretty clearly, and even you were saying, like, that pretty clearly can't be so, right? Like, it cannot be that, again, I have to go to NYPD and be like, Tucker's people are really mean to me, can I have a gun? And NYPD can be like, no. What? What? What do you mean no, right? If I wanted one, which again, I don't, because it's dangerous, but you see what's like, so like the actual legal issue here, the problem is not that, the problem to me with the brief is, again, not that the brief is wrong, the brief is right. The problem is what is Alito going to do with it? What is Thomas going to do with it, right? Because it's, and what is Kavanaugh going to do with it? This particular court has been looking for opportunities, and just, here's the last point. And remember that they're looking for opportunities over and against public opinion. We have, if you check the Gallup poll or pretty much any other publicly available polling on this, right? The tolerance for Americans have for gun regulations and restrictions is going up, 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 up. The support for background checks is going up, 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 up. We have a ridiculously reactionary Supreme Court that is completely out of touch with where the rest of the country is on this particular issue. And they're using these like small cabled, what should have been small and cabled legal, right?
These petitioners' applications for self-defense filing, that's all it says.
Right? It's the current, it's the kind of unhinged Supreme Court that is putting itself in a position to look for any opportunity to expand the gun rights that unbalances the kind of the entire discussion, right?
Right, how are we on time, Jake? I know we started about 10 or 15 minutes. All right, we've got a question here, and then up here.
Hi, thank you both so much for taking the time to be here today. I have a question about the loss of institutional faith and, you know, some of the individual drivers of decision-making that you alluded to when it comes to the decision to not only own a gun, but to carry it out into public. Words are hard. And so I guess, you know, one of the most alarming things for me over the last 2 years has been to see, alongside a historic increase in gun violence, also a historic increase in the levels of minority and female first-time ownership of guns. And in my personal life, that's been illustrated by friends of mine, right? Asian women who have never in their lives thought about touching a gun ever, wondering for the first time if they need to own a gun. And what that speaks to for me is like a fundamental shattering of the sort of institutional faith in like the police or the legislatures or the courts to keep us safe in the ways that are most meaningful to people, right? Like my family and me ought to have the right to walk down Times Square without being physically assaulted. And when you don't have that level of belief, whether because institutions have failed, you know, people their whole lives or throughout American history, it seems that institutions might be poorly positioned to address these problems, right? And so I guess my question is, approaching this like almost a messaging problem, right? Like a PR issue where I feel like part of the reason why these sentiments are taking off is that we have a very well-funded gun manufacturers lobby telling people not only, yes, you should be afraid, but the only way that you can address these fears is by buying our products. It's almost like a deprogramming effort, right? Where like people have been swept up in a cult mentality, and now we need to find ways to communicate with them the facts, which are that having a gun in the home is more dangerous than not having a gun out in Times Square on the street, but to do it with a level of sensitivity that addresses like these underlying concerns for so many people. And so I'm wondering if, you know, either conceptually or based off of your experience on the ground with clients, Julia, and Ellie, you know, whether there might be ways that we could approach this in a way that does exactly that. It is by changing the decision-making that undergirds the like rampant casual carrying of guns.
So I think that when it comes to what's happening on the ground with our clients, they are facing real dangers, right? Izell spoke of, you know, clients who are possessing firearms, and sometimes they aren't loaded, they're in the home, they're in a safe or whatever. But there are situations where our clients have actually possessed a firearm and used it in self-defense, discharged it and used it in self-defense, and they were exonerated for, I'm thinking of one case in particular where it was a homicide. A young man was, his family was in the car, his wife, daughter, and father were in a car waiting for him. He was coming down from his apartment, and as he's approaching, there was another young man who came up to the car and began to open fire. And our client, thankfully, or luckily, or fortuitously, had a firearm, and he was able to use it and protect his family, and he killed that other person. And the person, the district attorney's office did not charge him for the murder, but they said that they were going to go hard on him for the possession of the firearm. And so there is a real need for people to have the option to protect themselves in high crime neighborhoods. There is a need for our clients to have the option to protect themselves if they are law abiding. Just like if you go into white neighborhoods, there are people there who own guns for self-protection. And there's not an issue with that. They're law abiding white people. And no one seems to think that they're going to cause more deaths necessarily or somehow put the public at risk because they're owning firearms. And so I think first that we need to acknowledge it's not a matter, there is some fear mongering that's going on, but it's actually a real issue of safety, which is why a lot of people of color would like to possess guns, or at least should have the option of possessing guns. And I think that's another point that needs to be made, right? If you have the right, it's not a requirement. So Ellie says that, you know, he gets threats when he goes on Tucker, understandably so.
No, when Tucker, I don't go on Tucker. Tucker finds a clip of something I said.
Oh, okay, okay.
Go on Tucker. I'm not crazy.
Well, he gets threats, right, whenever he appears there. And his friends have told him, well, you should get a firearm, and I'm assuming that some of them have. And then I'm assuming some of them haven't. And you have weighed the option, and you've decided that that's not what's best for you and your family, and that is your right. And there's another person who may be in your situation who maybe doesn't have the considerations that you have, or are willing to, you know, figure out ways to make their family safe, and they think that having a firearm to protect themselves in those situations is something that they need to do, and they should have the option to choose that. And so, you know, there seems to be this assumption that because, you know, if we somehow allow people the option to opt to carry firearms, that everyone's going to opt to do that. And then we're just going to have, you know, a ton of people in the streets with guns, and New York is going to turn into a big standoff. And that just hasn't happened in the states that have, in recent years, really over the last 30 or so years, moved to shall issue regimes or constitutional carry regimes. So, yeah.
I would just add that I'll go back to Hobbes, right? Thomas Hobbes, the state needs a monopoly of force. right? It's the state is supposed to have a monopoly of force. And where the state cannot execute a monopoly of force to protect itself and its citizens, then citizens have the right to protect themselves. And so what you have in a lot of minority communities, the Asian American community, especially during the COVID-19 pandemic, the Black American community, like all the goddamn time, is a sense that police are not capable of protecting us in our own communities. You were saying that there are lots of factors for why I haven't chosen to buy a weapon, whereas maybe some of my other Black media friends have. Yeah, I live in a white suburbs. That's one of the factors, right? I have relative, look, I would never call the cops unless I absolutely had to. But if I absolutely had to, I have some confidence that the cops would show up in a timely manner and be able to deal with my problem in an appropriate way. Some confidence, not a lot, but some, right? Certainly much more confidence than I would have if I was living north of 125th Street, right? So but what's your question here? Your question is, well, how do we start to change the culture and change the perception of the friends that you're talking about who, for the first time in their lives, are thinking maybe they should own a gun? The way that you start to change that perception is that you show that they can be protected through the structures of the state. And the state has done a terrible job of proving that to this point, right? For various reasons, many of them racially related, and some of them just because the state is bad at things. And so you have to imagine a world where the state is, you have to show people that the state is actually able of solving their problems and doing the protection work to get people in your communities and my communities to lay down their arms, right? Now, white communities have always felt in this country like they are just, that is part of their God-given right to be able to protect themselves, right? Like that is one, we talk about American exceptionalism a lot in this country, and it's one of the things that is exceptional about America. It's that we're bloodthirsty. There's a quote that I like from the British. It's Americans coming over for World War I, right? So World War I's been raging in Europe for years, and everybody's dying, and it's gross, and there's mustard gas, and it's bad. And the Americans are like, we're here to help, right? Like coming in at the very end. And the British were like, these people have no idea how to fight, because they haven't been in this trench war. They have no idea how to fight. They have no organization. They don't know what they're doing, but they're good shots. They're good shots. That's the American exceptionalism. We have a culture of gun violence in this country from our founding that has never really been addressed. And so, yes, I'm talking about starting to do the things that would address it, but that's a much longer tail project.
I appreciate that. We'll go to our next one. When you first started, I thought this was about to be a defense of the Leviathan, and I almost spilled my coffee. But it ended up being quite nuanced. I appreciate that. Right there and then
Thanks
here.
so much. I want to thank all of you, and particularly the two panelists. And I appreciate your remarks, and I agree with a huge percentage of everything that you both presented. I just want to offer a comment, which is that we've been hearing a lot about, more guns, more people dying, and whether that's dubious, the studies that say that. And I just want to draw a distinction because, yes, the last 2 years we've seen record-breaking profits for the gun industry because there have been record-breaking gun sales, and we've also seen record-breaking increases in the number of people that have been dying of gun violence. Now, I think that's correlation, not causation, because there's an awful lot of other things that have been happening in the last 2 years. But I think the studies that really were presented in most of the briefing in this case were not about more people owning guns causing more people to be killed. It's about more people carrying guns in public being associated with more people being killed. And if you look at the pure number of guns being owned, it's not going to correlate to crime so much because it's not evenly distributed. 50% of the 300 million guns in this country are owned by 3% of the country.
Yep.
And I would submit that those 3% are not able to carry all those guns in public at the same time. These are arsenals that fill their garage. But the studies that look at relaxing the ability to carry guns in public, John Donahue at Stanford is sort of the leading expert on this, show that when we relax restrictions on carrying guns in public, and we do have more people carrying guns in public, not owning more guns, not buying more guns, we do see violent crime increasing, we do see violent assaults increasing, we do see people being shot fatally or otherwise. So I think it's important, and I agree with the diagnosis of the problem. I agree that the way on the front end, New York's permitting law is administered in a racist way. I agree that the way the law is enforced by law enforcement and by the courts is racially disproportionate and problematic. But just to push at that notion of rejecting studies that suggest that when more people are carrying guns in public, more people are going to get shot. I think to the extent this case is, as various people have said, is not going to solve the myriad conditions and factors that contribute to gun violence. But what this case can and will do is, in states with a quarter of the U.S. population, result in more people carrying guns in some of the largest cities in the country. I think it's safe to assume that it's going to be consistent with the rest of the country's experience that when more people carry guns in public, it leads to more armed confrontations and more people being shot. And I think as someone who, like Layla, did also file an amicus brief supporting New York in this case, agree 100% with addressing all the problematic ways of the way this law is administered and enforced. But I do just want to draw the distinction between more guns being owned versus more guns being carried and what the studies show. And I think that to the extent that distinction is elided in rejecting the data, it perhaps undermines the persuasiveness of the diagnosis that your brief suggested, even though I completely concur, the prescription to solve the problem, even though I completely agree with the diagnosis of the problem.
In light of time, we've got one more here, and we'll let Riva, before you go, Riva, it seems like you have something right on point.
Well, no, I just want to say one really modest thing to the authors of the brief. We don't know each other, and I only want to say I don't know what you've heard of what we've argued in our paper because you heard reason to it. We at length affirmed the brief for making audible to the nation as a whole the very problem that's just been that this whole day has been about, really, over and over again. And so we did not and do not dismiss the brief in any way. Really, ever since I went into teaching too long ago, I've written on both race discrimination in our constitutional order and the failure of our Supreme Court to deal with it. So that's where our writing is coming from. And I just want you to hear that and not hear it in any other spirit. And that's all I want to say to people otherwise in the term.
Thanks.
Thank you. That's really all it is.
So we've got one more question, then I'll let both of you respond briefly to the last two questions and comments. So.
Right. So I think what, to sort of pull in some threads of my work and what Joseph and the public defenders have done and what Ellie has said is, let's take as a premise that what we're trying to figure out is what is going to be best for Black people, right? And then the question isn't regulation versus deregulation, it's the comparative costs of regulation versus deregulation. Because regulation has costs, as you ably outline in the brief, but deregulation also has costs. And those costs aren't necessarily present as much as they could be in the briefing. The second thing I want to point out is that it feels like you can't do this cost analysis, you can't do an estimation without understanding the kind of ecology in which it's working. It'd be one thing to talk about a deregulatory gun program in an environment in which everything else was fixed, but it's also happening at the same time that you have widespread loosening of substantive criminal law, self-defense, the emboldenedness of public carry, public actions of public policing by private parties. And so it's not just the one metric that we have to be worried about. We have to be worried about this entire ecology that's not the same in every single jurisdiction, even though the Second Amendment might be. The other thing that I want to highlight is that in doing this cost-benefit analysis, there's a bunch of hidden costs that Riva and Joseph and others have identified, which is it's not just the people that get injured, it's the, how do we account for the fact that we are maybe 1-2 presidential elections away from a call for, armed patriots to go to major urban centers to make sure that the vote is not tampered with. And the effect that that would have on political participation by communities of color is say, I'll be damned if I'm going to the polling place if I've got to actually go through a gauntlet of suburban, heavily armed people to get there. How are we going to account for that in this calculus about what is good for Black people? And the last thing that I'll point out is, that one of the things that I worry about is the deregulatory apparatus in this ecology is somewhat insensitive to the levers of political power that Black people have in particular. That is, if it's localized, right, then you can use Black political power to make change. But if the decision about gun policy or whatever is either taken out of the political process altogether because it's a Second Amendment matter, or is at some other level of government regulation like the state, that totally dilutes Black power. Then the decisions are made about crime, about guns, about policing, about use of violence by states that tend to be heavily gerrymandered and skew towards the political priorities of white, rural individuals rather than people in diverse urban centers.
Right, briefly, we've got just a couple minutes.
I'll let you go ahead and answer that.
Okay, so to close, I'm so happy you brought up the patriot voting issue, because there are two things that could make me buy a gun: the zombie apocalypse and having to defeat MAGA on my way to go vote. Like, those are the two things I'm like, all right, I gotta regulate up. I want to close by emphasizing something I kind of mentioned, but it occurs to me I probably didn't hit this hard enough in my opening. I do think that there is a bit of a silver bullet here. And to me, that silver bullet is the protection of women. The most dangerous thing for an American woman is an American man with a gun. Whether it's her partner or just some idiot on the street, that's the most dangerous thing. And if we could and what we see so often is that so many other crimes that we're concerned about start with domestic violence, right? So like the cop who eventually shoots my son for buying a Skittles, probably was a domestic abuser back at home, right? If we could hone in on the specific violence against women, if we could hone in on getting guns out of the hands of people who commit violence against women, if we can hone in on laws that make it much harder for you to get firearms if you have committed violence against women, I think that becomes, it's not a full answer, it's not a full silver bullet, but it becomes a way to really, I think, change our criminal justice system. Because so many of the crimes that we care about start with crimes that too often the system doesn't care about. So I guess my last kind of thing is never lose sight of the real victims in all of this, because the real victims most often are women.
I'll just say that, I think that one of the things that we haven't talked about too much is how we will achieve public safety. I think that, you mentioned that, I think you said 60% of gun deaths are suicides, right? That's a mental health problem. That's something that we need to address, not through deregulating guns necessarily, but through addressing the underlying causes. And that also speaks to a lot of what's the causes of high crime and violence in Black and brown communities is, historical trauma and the inability to cope and the inability to have adequate conflict resolution skills. And so I think, you know, in terms of, on the one hand, we have the right to bear arms, which should not, in my opinion, should not be infringed upon. And if there's going to be some sort of regulation, it needs to apply equally across the board for all races. And I think that we should have the option as Americans. I mean, we have a ton of guns in this country. We're not getting rid of them. And even if we were to ban guns and abolish the Second Amendment, we still have the guns in the country. That's just going to push them all into the hands of the people who we don't want to have them. And so we actually have to figure out how we're going to deal with a country that is awash with guns and how we're going to achieve safety. And so we need to, you know, this idea of going after men who abuse women, I think that, you know, that's important, but I also think that it's important to address the causes of domestic violence, and not through the criminal judicial system, but through community interventions. Because oftentimes in the cases where I have domestic violence, neither one of the parties wants to go forward. Sometimes it's not even them who contacted the police, they just happen to show up because they're always in our neighborhoods. And so it doesn't solve the root causes. And I think that, you know, if we start thinking about how we're going to address, you know, public safety in ways that don't involve policing and violence, that would be a step in the right direction.
So let me just close in the last 30 seconds with a couple observations. The first, I'll put back on my public defender hat. A million years ago, when I was director of DC's PDS, we started the country's first special litigation division, which focused only on impact litigation. And I'll give voice to a prior that public defenders share that may or may not be front of mind for a broader audience. So for the public defender, our goal is to represent the expressed, narrow, partisan interests of our client. And when several of our clients have very similar expressed, narrow, partisan interests, then we engage in impact litigation and furtherance of those issues. And in this case, if clients of the public defenders are being negatively impacted because of gun laws that disproportionately affect them, even if they are acquitted on the underlying homicide, but get X number of years on the gun case, that becomes a problem for the public defender, and the public defender engages in litigation to redress that problem. The theory behind it is that if we can convince courts to treat Black and brown and underprivileged people the same as everyone else in one instance, then we can convince courts to do that in other instances. And each little victory helps. There are counter arguments, obviously, and folks have interests with respect to a broader range of competing interests may come into play. But for the public defender, that's the thing that they worry about. Again, the narrow partisan expressed interest, and that's their ethical duty to do that. Everything has shards, and a couple shards, I'll just say in the last 10 seconds, pop from this, and maybe someone will do a panel later. Ellie says not courts, not legislators, not legislation, but the people that populate those institutions. Obviously a question we didn't get to is how do we do that? And, history doesn't leave me sort of bubbling with confidence that it can happen or will happen. So, for the next time we might engage in a conversation about, how do we change the people that physically sit in these institutions?
Shotguns.
And the second, actually right in this room, just several years ago, I moderated, what was his name? The guy who wrote The Negro and the Gun. We were literally in this.
Johnson.
Yeah, thank you. literally in this room. And, you know, the second sort of shard, I alluded to it here briefly, and this is my public defender hat on, and it's the tension between the sort of individual needs of a specific client and sort of broader aims that come to play in impact litigation, because sometimes those two can bump heads, and how do we mediate that tension? But this has been a wonderful panel and a wonderful and thoughtful audience. The last thing I'll say is I teach trial advocacy, and a predicate, one of the things I teach is trial advocacy, and a predicate of trial advocacy is the concepts of primacy and recency. So I teach budding trial lawyers that you start strong and end strong, because that's how you capture the attention of people. And I'm going to use your opening line, the Second Amendment is about killing black people, as an example of primacy. That wakes you up, that wakes an audience up, and it captures their attention immediately. So these things sometimes have spillover effect, so I appreciate that. I will turn it over to, I don't know who, to Jake? Thank you.